Mr. Chairman, my name was invoked.
I noticed.
As a proud Democrat, we were like
My
that part of
name
your
was
history.
invoked, Mr. Chairman. Now, I just want to let the record reflect, and I love Senator Whitehouse.
Uh-oh.
But I'll tell you one thing, I've never been a Marxist. I've never been a Marxist. And I've never admitted I was a Marxist and then not turned the document over to this committee. We had to find it. And we did. And now your testimony, the testimony under oath today is, I didn't say that. The reporter said that. No, the witness said that. And then the testimony is, well, I didn't mean it to become public. That's not the issue. So, you know, if we won't get personal here, we can.
Senator Graham?
Thank you. Let's agree on the following. A Louisiana Democrat's probably not a Marxist.
Thank you, Mr. Chairman. The White House counsel's office, as we all know, is the part of the White House that is charged with advancing a president's nominees to the federal judiciary. Every president in recent memory has had a White House counsel's office. And all White House counsel offices do their job. They try to, they think they're right, and they try to get what their boss wants. And of course, all senators think they're right, and we try to get what we want. It took, I think this is true of all White House counsel offices. It took a while for President Biden's White House counsel's office and I to get to know each other. But we have. Now, I'm not suggesting that we are ready to go to summer camp together, and it could all fall apart tomorrow. But we have had a number of vacancies on the federal judiciary in Louisiana. We need to fill them. Working with White House counsel's office and my quarterback, Senator Cassidy, we filled 2 of them. Today, we have 2 additional splendid nominees to offer up to you. I returned a blue slip on both of them, and unless they really, really, really screw up today, which I do not think they will, I'm going to vote for them. Senator Cassidy covered Jerry's and Brandon's resumes. Look, I'm not going to repeat everything, but if you look at these 2 gentlemen and aren't impressed, as Lindsey Graham says, you shouldn't be driving. Mr. Edwards graduated from Georgia State University, Vermont Law School. He's clerked for 2 district court judges in Louisiana, 1 Republican, 1 Democrat. He spent 13 years at Blanchard Walker, a hell of a law firm. He was a partner there. He's been the chief of the civil division in the U.S. Attorney's Office in the Western District. He's been rated unanimously well qualified by the ABA. Brandon Long, Mr. Long, is he's from New Orleans, actually Metairie. He went to the University of Texas. He graduated cum laude from Duke Law School. Spent 5 years at King and Spalding. Was earning a great living. Decided to get into government service. We appreciate that. He's been a federal criminal prosecutor in both D.C. and the Eastern District of Louisiana. He's tried 32 cases to verdict. I think Mr. Edwards has tried a bunch of cases to verdict as well. He was FBI Director Ray's Deputy Chief of Staff for a while, and he's eminently qualified. I've gotten to know both of these gentlemen. Each of them is smart. Each of them is principled. Each of them has thought about the world. and they've formed opinions about the world, but I am convinced that they will limit their decisions to the law and to the facts of a specific case. Each understands the role of our Madisonian system of checks and balances and separation of powers, and each of them understands the importance and the nuances and the limitations of the law. And I'm really glad we could get this all worked out. And my work here is done. That Senator Booker has a silver tongue, doesn't he? He's good. I know Mr. Long and I know Mr. Edwards. I don't know Mr. Hodgie or Judge Maddox. Congratulations to all four of you, though. Judge Maddox, I think I'll start with you. I just want to talk about the law a little bit. I stipulate that you will follow the law and apply it to the facts of the case as you are guided, including but not limited to precedent. I thought the Supreme Court just handed down some really interesting decisions. One of them has not been talked about much, but I found it fascinating. Tell me about Moore v. Harper. That was the independent state legislature theory. What's that all about?
Good morning, Senator.
Good morning.
Yes, Moore v. Harper concerned whether or not the Elections Clause in Article 1 of the Constitution gave the state legislature sole authority to regulate elections for federal office in their states without any judicial oversight. Mm-hmm. And the Supreme Court held that the Elections Clause did not preclude judicial oversight of the legislature's regulation of federal elections.
I can tell you looked at the case. Here's one way of looking at it. Every state has a state constitution. And I want you to tell me if you think I'm wrong here. Every state has a state constitution. And in fact, many state constitutions preceded the federal constitution. And some of the provisions in our federal constitution were copied directly from state constitutions. And as I read Moore v. Harper, what the Supreme Court is saying to a state legislature is, look, yes, Congress gave you the power to draw congressional districts, but you've got to do it consistent with your state constitution. And so the state courts get to weigh in. And if the state courts don't render opinions that are consistent with the federal constitution, then the federal courts get to weigh in. What do you think?
I believe that that's a fair reading of, or maybe perhaps reading between the lines of that opinion. That particular question is not one that I'd considered previously, although I have reviewed that opinion.
Yeah, I just found the whole case very interesting because the theory of the plaintiffs was that state legislatures can do anything they want to do with respect to congressional reapportionment because Congress gave them power. But it ignored the role of the federal judiciary and the state constitutions, which, anyway. Mr. Hodgie, tell me about, I need to get a life, I guess. Mr. Hodgie, tell me about this Waters of the United States controversy. What's it all really about?
Senator, I'm not, I've been an attorney for 12 years with the Navy, and I've practiced in government contract law for a long time, and I've worked on those kinds of issues for the last almost 12 years. I haven't encountered that particular issue that you're referencing.
Okay. All right. Tell me, this will be my last question. Tell me, doesn't strict liability seem inherently unfair to you?
So my understanding of strict liability, Senator, is that there's limited circumstances for when it's applied. My
Like what?
job,
Like what?
excuse me,
Give me some examples.
like in product liability case,
Yeah.
for example. And I think the idea of strict liability is under those limited circumstances to encourage the right sort of behavior for, let's say, a product manufacturer to not create a product that's going to kill a baby, for example, that severe consequences have to ensue.
Well, I'm not saying I disagree with you, but tell me, how does it comport with due process? I mean, this is basically, some would argue, this is basically a legislature saying, hey, if you do it, you're automatically liable. You don't get due process. You don't get to defend yourself. There are no defenses. What do you think about that?
Well, my understanding is that strict liability comports with due process because you have the right to be heard in court. And it's, I think, a good example of the balancing of the branches of government from that perspective, because it, like you said, takes Congress's perspective into consideration as well.
Thank you, gentlemen. Thank you, Mr. Chairman. Thank you, Mr. Chairman. Congratulations to all of the nominees. Judge Mahalchek, you remember a case called Yentzer v. Potter County?
I have a recollection that I presided over that case. I don't know if I recall the details of it.
Okay, and you were reversed, is that right?
I believe that was a case that I issued. I was a magistrate judge in that role and in the referral role on it, and it was reviewed by the district court, yes.
And you were reversed, right?
I don't recall in that case if the report and the recommendation was adopted in full or not adopted
Well,
in full, but yes.
the higher court said you incorrectly analyzed qualified immunity and you incorrectly cited the 11th Amendment. Do you remember a case called Myers v. Clinton County Correctional Facility?
I recall that case as well.
And you were reversed in that case too, weren't you?
I believe it was adopted in part, yes.
Do you remember a case called Dennis v. Sheridan?
Yes, I believe I recall that case as well.
And you were reversed in that case too?
I believe that R&R was not adopted in full, correct, yes.
Okay, but you were reversed.
It was not adopted, yes,
Is that
by
the
the
same
district
thing
court.
as being reversed?
It's a different, the district court declined to adopt the report and
The higher
recommendation
court
in
said
full.
you were wrong.
The district court disagreed with my report, yes.
Yeah, okay. Do you remember a case called Shania v. East Pennsboro?
Yeah, the Shanias are pro se plaintiffs who have brought a number of cases, so I'm
Right,
not sure which
right.
one you're referring to,
I'm-
but yes.
I'm just curious, you were reversed in that case too, were you not?
In part, yes.
Okay. Do you remember a case called Spanier v. Libby?
Yes, I do.
The president of Pennsylvania State University was convicted of covering up child sex abuse crimes. And you let him go on a habeas corpus petition. And the Third Circuit reversed you, is that right?
I directed that a new trial should be held with a different jury instruction, and the Third Circuit disagreed and found that he had received the due process he was entitled to, yes.
Well, the Third Circuit said you failed to cite, analyze, or properly apply the relevant case law. You were reversed, right?
The Third Circuit reversed my decision, yes.
Okay. Do you remember a case called Hassel v. Centric Bank?
I vaguely recall that case, yes, Senator.
You were reversed, weren't you?
I believe the district court failed to declined to adopt my recommendation, yes.
Do you remember a case called Ramsey v. Amtrak?
Yes, I do.
And the higher court reversed you in that case too, didn't they?
The district court concluded that I was correct in finding that the petitioner did not pay a filing fee, and where I had recommended that the case be dismissed, he granted the petitioner 30 days to correct that.
So you were reversed in part,
Yes.
okay? Do you remember a case called McCracken v. Fulton County?
Yes, I do.
You were reversed in that case too, weren't you?
I believe that was in part, yes.
You remember a case called Bird v. Britton?
I do.
And were you reversed in that case?
In part, yes.
Okay. You remember whoa, I'm sorry. You remember a case called Allen v. Lackawanna County Board of Commissioners?
I believe I recall that case, Senator.
And you
I'm not
were
sure.
reversed in that case too, weren't you?
I believe I was reversed in part in that case, yes.
You remember a case called Daniels v. Capital One Bank?
Yes.
And I believe you were reversed in that case too?
I believe it was, yes, I believe so.
Do you remember a case called Downey v. Pennsylvania Department of Corrections?
Yes, I recall that case.
And were you reversed in that case?
Yes, I believe I was.
Remember a case called Rejean v. Wetzel?
I vaguely recalled that case, yes, sir.
And were you reversed by a higher court there too?
I believe that our report and recommendation was not adopted in full.
Okay, I don't have time to finish this list. I mean, it's longer than King Kong's arm here. You've been reversed a lot. In fact, you've been nominated before, haven't you?
No, I have not, sir.
Well, your nomination was talked about, and Senator Toomey refused to send in a blue slip for you, did he not?
I'm not sure exactly what happened. I know that this process has been ongoing for 2 years.
Yeah, but you know that Senator Toomey refused to even, thought you were so unqualified that he refused to even allow the Judiciary Committee to consider you. Isn't that correct?
I do not know what Senator Toomey's reasons were. So
You never talked to Senator Toomey about it?
I never discussed it with Senator
And you
Toomey,
don't
no.
know anything about a blue slip being withheld on you?
I do not know.
You're under oath.
I am under oath, and I know I did not speak with Senator Toomey about his reasons for not.
Was Senator Toomey's concerned that you were unqualified?
Again, Senator, I did not speak with Senator Toomey or his staff about his reasons for not supporting me.
Okay, thank you, Mr. Chairman. Thank you, Mr. Chairman. Judge Casaby, I'm looking at an order you issued as a magistrate judge here requiring the use of pronouns in your court. Do you require the use of pronouns, the declaration of one's pronouns in your court?
Senator, that may be referring to perhaps a trial management order or a scheduling order of some kind.
Yeah. No, it's a statement. You issued it. Here it is.
It's an invitation for people to identify their pronouns and or their honorifics.
Well, I'm looking at your requirement that you issued to all people in your court. You say, quote, when you introduce yourself in a meeting, you should say, my name is Judge Blank and my pronouns are blank. Is that right?
Senator, those were not requirements or rules. Those were suggestions and
They were suggestions.
Those were suggestions and invitations for people
Okay.
to use.
And you also, in your directive, you say, quote, I'd like counsel to introduce themselves, giving your full name and your honorific, such as Ms., MS period, Mix, or Mr., not Mrs. And if your client will be making an appearance, I ask you to please introduce them to the court by giving me their full name and their honorific, such as Ms., MS period, Mix, or Mr. End quote. Is that right?
Senator, it's not a directive. Again, it's an invitation for people to
Or it's
introduce
an
themselves.
invitation?
Yeah.
Okay. All right. I'm looking at an article from the Oregon State Bar Bulletin from May of 2021. And I want to read one of your quotes. Quote, we have to set aside conventional ideas of proof. Let me say that again. We have to set aside conventional ideas of proof, you said, when we are dealing with the personal and interpersonal work of equity, division, and inclusion. As a judge, I can appreciate the challenge of employing a different mode for understanding truth than that which most lawyers are accustomed to in our work, end quote. Did you write that?
That is a quote from that article.
So when we're dealing with equity, diversity, and inclusion, we should set aside conventional ideas of proof. Is that right?
In the larger context of interpersonal and personal relationships, the idea of being able to have a conversation with somebody,
Yeah, but you didn't talk about a conversation. You said proof.
it's in the context of having a conversation with somebody about the issue of their background and their
So
experience.
when the issue is equity, diversity, or inclusion, we should have a different set of proof. Is that right?
When it comes to the space in which people have interpersonal relationships with one another, the idea of respecting and dignifying each other with their experiences is an important part of.
So all issues have one set of proof, which has been handed down by our state Supreme Courts, our U.S. Supreme Court, except you think we ought to have a different set of proof when equity, diversity, and inclusion are at issue. Is that right?
In all of my years on the bench, Senator, I have applied the law, the rules of evidence, the
Okay.
case precedent.
Let me move on. I'm looking at the notes you gave us from a speech you made in February 7, 2020. It's entitled Speech Reflections on Equity and Privilege to the Oregon Blacks in Government. You wrote, quote, "White, male, straight people allow privilege to remain in place," close quote. Did you say that? Did you write that?
Without looking at the specific
Here it is.
speech
You
here.
turned it in.
Well, if that's on the piece of paper, Senator, then I have no
Okay.
reason to disagree.
You also wrote, quote, "Privilege is incredibly similar to narcissistic personality disorder," close quote. Did you write that?
Without looking at everything in the context of that statement, it appears correct.
Okay. You wrote, quote, "The identity of Muslims also need to be normalized in a country that is so deeply Islamophobic." Did you write that?
Senator, I did. And what I'd also like to clarify is that in the context of my work on the bench, I have treated everybody equally without regard to their
I'm sorry, I
background.
just want to get through this. I'm going to run out of time. You also wrote, quote, "I am disappointed about the way in which the founding fathers of this country perpetuated inequity," close quote. Did you write that?
In the context of the issue of slavery, that was something that I had been considering.
In your notes you gave us from a speech on May 17th, 2023, "Does race matter?" You said, quote, "Does race matter? Hell yes," close quote. You know that T-shirt at the Saturday markets, the one that says something like "Love, see no color," and it has all the colors of the rainbow all over it, and it's like a tie-dye shirt. Well, the first time I saw it, I said, "Ah, how sweet." Then I got angry. "If love doesn't see color, then I don't have allies," close quote. Did you say that?
Yes, and that was to explain that the work of equity is to help understand where people are coming from, not to ignore who they are.
And you also, yeah, no, I'm sorry. Can I have 30 more seconds? Judge, you seem to be obsessed with race and sexuality. I mean, you even go so far as to say that when race and sexuality and diversity and inclusion are at issue, we need a separate standard of proof in the United States federal judiciary. How are litigants going to be able to trust you?
Senator, that's not what I've said. There is
Sure
no
it is.
different
Here it
standard.
is, bigger than Dallas. I read it to you.
When you look at-
turned in these documents. I didn't go looking for them.
When
You
you
seem
look at-
proud of it.
As anyone who reviews my record on the bench,
I
with
have.
thousands of cases.
I'm going to let you finish responding, and your time has expired, but go ahead.
The rule of law is an absolute for me. The work that I have done on the bench over the
That's
last
not what you
16,
say.
the work that I've done on the
But
bench,
that's not what you say.
Judge, finish your sentence.
the work that I've done on the bench in ruling over all the people's cases that have appeared in front of me from all backgrounds, of all faiths, you'll find that I have upheld the rule of law and upheld the precedent of our Constitution and our Supreme Court and the Ninth Circuit.
Well, if this chairman would give me time, I could go through the cases and prove that that's not the case.
Senator
I just don't see how you can be a fair-minded judge. Mr. A-Frame, how are you?
Good, Senator. How are you?
I'm well. What is rent control?
As I understand rent control, it's some cities may have laws that limit the ability of landlords to raise rent, but it's not something I'm that familiar with.
Okay. Well, why isn't that a taking that merits compensation from government?
I don't know whether that's been litigated or how that's been resolved. I have never dealt with rent control.
Well, I want to understand what you think about it, how you think. Why isn't it a taking? I mean, your government is taking money from the private owner of an apartment. Why isn't that a taking? Just like if they took his property to build a highway.
So I'm not well-versed enough in takings to give you a definitive answer, but I'll give you what I know about takings. And
No, tell me what you think. Tell
So,
me how you would analyze that case.
I would be looking at the precedents that say to what extent can government regulation be permitted.
Suppose there are no precedents. I know we'll stipulate you would look at precedents.
But
I want to know how you would analyze that case.
Well, the question is, what can the government do as far as regulation where there's still value in the property, but maybe not the maximum, and does that constitute a taking? That's what I'd have to study. I don't know the answer
Tell
about
me
that.
what you think about it. How would you analyze it?
Well, from what I know about,
What are the competing interests?
well, the competing interests are the government's interest in housing, I would think, on one side, the property owner's interest in making the maximum amount of money on the other.
Well, why couldn't the government, it has a legitimate interest to help poor people. Why couldn't the government accomplish that by just allocating some tax money to housing subsidies? And then you don't have to take somebody's private property.
That would be a policy decision, another way to try to get at that end. You're asking me whether it's a taking.
Yeah,
And I think that I am not sure that a limit on how much you can make constitute a taking, but I don't know that for sure. I would need to think about that and study that.
well, aside from, if you were back in private practice, how would you analyze that? How would you reach a decision?
Again,
Please don't tell me you go look at precedent, because
Well-
you're not going to find much.
I know that there are cases about regulation that limits the value of property. And I believe that those cases say, unless the property is basically brought down to no value or very little value, it's not a taking. That's my memory.
No,
and that
that's
would be
not
relevant.
accurate. That's
But
not
I could be wrong about that.
You can have a highway come through and take part of your property, which
Right.
diminishes the value, but you've still got to compensate the landowner, and you've got to compensate the landowner for consequential damages as well. That's clearly a taking. Why is rent control any different, Counselor?
Senator,
Achieve a government purpose in a less discriminatory way? Why isn't this open and shut?
well, Senator, without doing more work on it, I mean, I tried to tell you what I would think about it, but I'm also telling you I don't know necessarily how it would come out, and I would need to read and think about it more. But I would think about the government interest, understanding that there is a loss to the owner of the property, and figure out how those interact.
Okay, what's the new rule about how flexible an employer has to be if an employee asks for an accommodation because of a religious belief?
There has to be, the employer has to suffer a substantial hardship, which is a change in the law. The law was more, gave employers more flexibility in that area, and there was, I think the cases DeJoy from last term made that more difficult for employers, raised the burden on them.
Okay, fair enough. you will faithfully follow precedent, is that right?
Yes, Senator, I will do my very best to do that, yes.
Would you have followed the Dred Scott case?
As a lower level judge,
Yeah.
I mean,
It's a yes or no.
I think that, Senator, I mean, there's a
have
fidelity of lower court judges, and hopefully our Supreme Court would make the right decision
You
there.
have followed the Dred Scott case.
As a lower court judge, I think you have no choice, but you can write that the Supreme Court should do something about that, and I would have.
Would you have followed Plessy v. Ferguson?
It's the same answer. You have to. Agostini versus Felton said lower court judges must follow Supreme Court
Why
precedent.
wouldn't you quit first?
Well, I guess I hadn't thought of that option, Senator, but I would certainly make my voice heard, but I would have to follow the
Dred
precedent.
Scott was an immoral decision, do you?
Yes, Senator.
Okay, why wouldn't you quit?
Perhaps I would. I hadn't thought about it like that, Senator. I don't know. I hadn't thought about that.
Okay.
But I would make my voice heard. But I do want to say that in a vertical court of judicial system, it is critical that middle level judges do their best to follow precedent.
Thank you, Mr. Chairman. I just feel like I need to ask this question. Mr. Fonzone, when you advised the companies referenced, Huawei and others, you were at Sidley,
Yes, that's right, sir.
and when a client comes to Sidley, you have to fill out a form that says, here's my client name, here's my mailing address for business purposes, and here are my political beliefs. Is that the way it works?
There's definitely a client intake process. I don't remember all the particulars of
I
it.
mean, big law it's kind of like who can pay the freight, right?
That's an aspect of the
Okay.
intake process, I'm sure.
I understand. Professor, I'm looking at a letter dated March 16, 2020. It's a letter to Governor Lamont in Connecticut. The title of it is Urgent Action Needed to Protect Individuals in Connecticut's Prisons and Jails from Coronavirus 19 Pandemic. Did you sign that letter?
So I don't recall sitting here today, Senator.
Here's your signature. Here it is back here. Why didn't you turn this over to us when you were asked to submit documents?
So, Senator, I made every effort to search for everything that I had ever signed. That's not a letter I remember, but I will certainly take a look at that. And
We found it was with a search on the internet.
so I apologize, Senator. I apologize.
In
that I
your
missed
letter
that.
to the governor, here's what you say. As they stand, prisons and jails are detrimental to public health and human rights and disproportionately harm marginalized communities, including Black, Brown, Indigenous, and other communities of color, immigrants, people with mental illness, people with disabilities, people in the LGBTQ plus community, people who use drugs, people engaged in sex work and street economies, and people experiencing houselessness and poverty. So if you believe that about our prisons, how are you going to ever send somebody to prison?
So, Senator, I will need to take a look at that letter, and I apologize that that's not something I found to hand to this committee.
You're not denying you said that.
I do need to see the letter to see the context, because again, it's not something I remember adding my name to. I can assure you,
Right.
Senator.
And you also say, first, you call on Governor Lamont to release everybody in jail. Is that right? Because of the coronavirus?
So again, Senator, I would need to see that letter in front of me. It certainly was not.
You can find it just put your name into Google. You'll find it in about 3 nanoseconds.
I will, Senator. I can assure you that
You said in your letter, Professor, we call on Governor Lamont, state of Connecticut, and all Connecticut jurisdictions to immediate release to the maximum extent possible people incarcerated pre-trial and post-conviction. And then you go on to say, talking once again about our jails, the global COVID-19 pandemic is throwing into sharp relief the untenable state of our penal system and the need for sustained action to shrink its scale, shrink its size, and shrink its scope. You sound here like the district attorney in San Francisco. If you believe that, how are you going to ever sentence anybody to jail, Professor?
I can assure you, Senator, that I understand the role of the judge and that I can assure you prison time is an appropriate sentence in
That's
many
not what
cases.
you say here to the governor. You wrote the governor. This isn't some DoorDash delivery guy. You wrote the governor of your state 3 years ago.
So again,
I went
Senator,
in law school.
So again, Senator, I would need to look at the letter. It sounds like it was written at the height of the pandemic where governors were looking for.
You also wrote the governor, you said, people over the age of 55 are at the greatest risk for COVID-19, but also pose the least public safety risk to our communities. People in this age group can and should be released immediately to mitigate the spread of COVID-19. You think the governor just, if you're over the age of 55, he should let everybody go?
No, Senator, that's not a position.
That's what you said.
Okay.
Here
and
it is, big as Dallas.
Again, Senator, I will look at that letter. I can assure you that.
Find it on Google, Professor. You also say Governor Lamont should issue an executive order to direct the state's attorney offices and law enforcement entities, including the town and city police departments, and any federal law enforcement entity operating within the state to immediately cease adding to the incarcerated prison population given the high risk of infection posed by the population increase. You asked the governors to tell every law enforcement official in the state to stop arresting people and putting them in jail, didn't you?
So again, Senator, I have to look at that letter. I do think there were modifications that the governors were making around the country to respond to the pandemic.
You also had an opinion in your letter about, can I have another 30 seconds, Mr. You had an opinion in your letter about immigration. You said immigration detention poses the same health risk to jails and prisons, and Connecticut law enforcement must stop feeding people into the unsafe and inhumane immigration detention system. Then you say Governor Lamont should release all individuals currently in state custody who are awaiting transfer to ICE custody, and the governor should declare a moratorium on all such future transfers. How, if somebody is in our country illegally and commits a crime, are you going to put them in jail if you believe this about immigration?
Senator, I can assure you, were I so fortunate to be confirmed, I would treat crimes seriously.
That's not what this letter says, Professor, and it was 3 years ago. It wasn't when you were in law school, and you didn't turn it over to us. We had to find it on our own.
Senator, the chair has been generous in time. I think you've had your opportunity. Would you like to complete your sentence or statements?
Thank you, Senator.
I didn't mean to cut you off, but Dick was going to cut me off, so
I understand. And I apologize. I made every effort to find anything that I had been associated with. There were many emails and internet searches and otherwise that I did. I apologize if this is something I missed. It sounds like it was a letter that many people signed on to it. I will certainly review that and supplement my submissions to the committee. So I apologize, Senator, for having missed that.
Thank you, Mr. Chairman. Congratulations to each of you. Ms. Hill, what is collateral estoppel?
Collateral estoppel. I think collateral estoppel, well, Senator, I will say that my 20 years of practice has primarily been dealing with issues relating to criminal law or relating to other areas of the law.
Yes, and if you don't know, just tell me.
I certainly do know collateral estoppel. I'm finding that the bright lights of the moment are making it hard for me to recall it.
Okay, so you don't recall it, okay. What is the amount in controversy requirement?
The amount in controversy requirement is $75,000. It typically governs, in many cases, almost any case in diversity jurisdiction in the federal courts.
Okay.
And certain other.
What does the 13th Amendment to the Constitution do?
It outlaws slavery.
What does the 7th Amendment do?
It ensures that all civil jury trials, that all civil cases in the United States are done by jury trial. That you have a right to a jury trial in a civil case.
Okay. What is the difference between a stay order and an injunction?
A stay order would prohibit, an injunction would restrain the parties from taking action. A stay order, I'm not sure that I actually can give you the.
Okay.
That.
Tell me about, you'll see a lot of this in federal court. Tell me about the multi-district litigation statute.
So I'm not extremely familiar with the multi-district litigation. I do know that multi-district litigation is often consolidated into a particular court. So all of the cases involving a particular type of issue, if there is a multi-district litigation, those will all be referred to one court and one judge who will then oversee the MDL. But I will confess I'm not super familiar with all the ins and outs of that.
Okay. What kind of constitutional claims are subject to intermediate judicial scrutiny?
Cases involving certain types of classes, such as gender or illegitimacy, are subject to intermediate scrutiny. Some types of speech, like commercial speech, would be subject to intermediate scrutiny.
Okay. Tell me what a 12B6 motion is.
It's a motion to dismiss a claim, or a motion to dismiss an issue for failure to state a claim.
Okay. And what's the standard for granting a summary judgment in federal court?
It says that there are no issues of material fact, and that the issue can therefore be decided as a matter of law.
Okay. What's the standard for deciding whether a particular punishment is cruel and unusual under the 8th Amendment?
So the particular standard the court has said, and I cannot recall the case, but it says that you have to look at not only whether it is would be shocking to the individuals at the time that it was written, so it's not purely a historical review, as some of them are purely historical, but also you have to look at how it has changed, how those values have changed with time. It's one of those cases, circumstances where the court says it's appropriate to look at how values have changed with time.
Well, our right against cruel and unusual punishment is a fundamental right, is it not?
It is.
Okay. How do you square what you just told me about the 8th Amendment with the case after case after case by the U.S. Supreme Court that says the definition of a fundamental right is one that's explicitly stated in the Constitution or deeply rooted in our history and tradition?
Yeah, I think that it is. I think it is deeply rooted in our history and tradition.
Yeah, but certain forms of punishment are not. If a form of punishment, it existed at the time of our founding, and it's deeply rooted in our history and tradition, you telling me that makes it automatically constitutional today? I thought you just told me.
No, I'm certainly not saying that. I'm not. What I say about it is really quite irrelevant, but the Supreme Court has said we look at it with a view to the changing values on these
why
issues.
The difference? I thought
they're
both fundamental rights. Why the difference?
I think that's a question that the Supreme Court's going to have to answer, whether or not they have.
I think it has. I'm just asking if you know.
I think I've answered the question to the best of my ability, Senator.
Okay. Thank you all.
Senator Hawley, going to return? No. I think that all the senators have appeared who are going to question today. Ms. Hill, I congratulate you on surviving the John Kennedy 6-minute bar exam?
My contracts teacher is going to be appalled, and I'm going to have to live with that, Senator, but thank you, Chair. Thank you.
If you promise to spare Miss Hill, I'll...
Did the White House give any of you any written materials to use to prepare,
They gave,
or digital materials?
they gave us, previous questions that had been asked by the panel.
And answers?
I think we had to go find the answers ourselves. I think we had to go watch the various committee
May I have a
meetings.
copy of that?
I don't have one, but I'm sure that it is literally just a list of questions.
I don't have a copy.
I don't have any copy.
Would you send me a copy? I'm easy to find. Would you send me a copy, Ms. Hill?
I will.
Okay. Would you each send me a copy?
yes,
So I can
Senator.
compare and make sure they're all the same. Okay. Thank you.
Senator, can we have a copy of your list of questions to share with
Sure.
other members?
I'll even give you the answer.
It's like a bar. It's like a bar review course.
Yes.
Thank you, Mr. Chairman. Mr. Sheriff, I'm a little confused by some of the answers, but let me ask Senator Badia's question a different way. In choosing a law clerk, do you believe that a law clerk applicant's race should be used to harm that person?
Neither to harm nor benefit, Senator. I believe that applicants should be considered based on their background and experience.
So you don't think a person's race should be used to harm them?
Correct, Senator.
You think a person's race should be used to help them?
Not in that context, Senator, no.
Okay. Raise your hand, please, for me if you're a dues-paying member of the American Bar Association. So 2 out of 6 are members? Judge Bissert, why aren't you a member?
Senator, I was a member for many years of the American Bar Association.
Why'd you get out?
Honestly, Senator, when I was a member, my law firm paid the dues.
Yeah.
And so I don't pay the dues for the American Bar Association, but I was very involved.
Find it
for many
irrelevant and not worth the money?
No, sir. As you know from my record, I actually co-chaired the section of litigation for a number of years, and I thought it was very beneficial as a lawyer.
But it wasn't important enough to you to pay yourself?
It wasn't so much that, Senator. It's just that many of the benefits of the American Bar Association, at least for judges, I'm already participating in what the administrative offices provide with training, which is really what I was doing as a lawyer.
So it was beneficial to you if somebody else paid for it?
No, sir. It's just that as a lawyer, I used it primarily for legal education.
Okay.
And as a judge.
I don't want to spend too much time on this. Just for the record, 2 out of 6 of our nominees today have chosen to be dues-paying members of the American Bar Association. Mr. Sheriff, how long have you been a member of the ACLU?
Senator, I believe I first contributed in 2019.
And how much money have you given them?
I believe it's approximately $100, $120.
And
a year, I'm sorry.
A year?
Yes.
Okay. And why did you first decide to contribute to them?
Senator, I contribute to
just briefly
charitable organizations. They work on First Amendment issues.
Yeah. Now, you're a member of the ACLU of Southern California.
That's correct.
All right. A couple years ago, the ACLU of Southern California put out a statement. They said that U.S. policing has, quote, historical roots in slave patrols, close quote. And the ACLU chapter of Southern California went on to say that police presence has, quote, devastating and discriminatory impacts on tens of thousands of California students, close quote. You agree with that?
Senator, I'm not familiar with that letter. I have never seen that letter.
But I just read it to you. You agree with what that letter said?
I don't have information relevant to that.
You don't agree with it, or you do agree with it?
I can talk to my experience in law
No,
enforcement.
sir, I'm asking you if you agree or disagree with the statement of an organization that you chose to join
Right, Senator.
as an assistant United States attorney.
I understand, Senator. I would have to know a lot more about where that comes from in
Another
order to
letter
evaluate
said,
it.
well, you're not doubting that I'm reading it to you accurately, are you?
No, I'm not, but I don't know what the basis for that information is
The
in the letter.
ACLU of Southern California also put out another statement. They said, quote, ICE is not welcome here, close quote. Do you agree with that statement?
Senator, nearly 20 years in my practice in the Eastern District of California, the office has worked closely with ICE.
Do you agree with
and,
that statement?
certainly, in terms of federal law enforcement, ICE is welcome, and we work closely with.
Maybe I'm not being clear. Do you agree or disagree with the statement that ICE should be welcome in California?
I believe that ICE carries out a legitimate legitimate function under federal law.
I understand. Give me one more minute, Mr. Chairman. Let me ask Mr. Leibowitz. I want to ask you, it's a constitutional question. I think we now understand that there's some people in America, and I dare say many of our college students and college professors, who believe, my words, not theirs, but this is what I see, who believe in diversity, equity, inclusion, and the right to kill Jews. To what extent is that point of view protected by the Constitution, and what, if any, limits are there on that point of view?
Senator, I very much appreciate the question, especially the times that we're living in. First, as your former colleague and now the president of one of the great universities in this country, the University of Florida, said, the First Amendment gives people the absolute right to be abject moral idiots. And Senator Ben Sasse, now President Sasse.
So does the Senate.
So I take part of your question that since October the 7th, I think part of what you were saying is that people are taking full advantage of their First Amendment rights. And the basic dividing line in answering your question, as I understand the court's precedents and the First Amendment, is that there's a very big difference between speech and conduct. There's a very big difference between things like Title VI, Title VII.
Let me stop you because I don't want to go too far over.
Yes.
I think you've made the correct distinction between speech and conduct. If I could have just 30 more seconds. Could the U.S. Department of Education, if a college professor crosses that line between speech and conduct, could President Biden's Department of Education withhold their federal funding?
Senator, I'm going to only be able to quickly answer part of your question. First of all, I do believe that part of the way you phrased it, I'm precluded from answering it because of the canons of judicial ethics, because there are live cases now and live statements now, as I understand it. There are live cases being brought under federal law tracking exactly what you're saying, and I'm not sure if the President's Department of Education wants to weigh into that or not, but if they did, and that case came before me, I wouldn't want my comments today to be viewed as prejudging them.
Thank you, Mr. Chairman.
Thank you, Senator.
Ms. Berner, you didn't tell Senator Graham the truth, did you?
Senator, I took an oath to tell the truth, and I have done so faithfully.
Now, on February 22nd, 2018, you spoke to the American Constitution Society, and this is what you said. the right to work movement is deeply racist. You said that, didn't you?
Senator, I do not have that speech in front of me. I have spoken on a number of occasions about the
You
history.
turned your notes over to us. You didn't read them before you turned them over?
Senator, I've spoken on a number of occasions about the history. I was not speaking
Are you
about.
saying that you didn't say that?
Senator, I've spoken on a number of occasions about the
Yes, ma'am,
history.
are you saying that you didn't say that?
I have turned over all of my notes from my speeches.
I don't think you're telling the truth, Ms. Berner. Let me ask you another question. Do you remember Mindy Sturgey?
No, sir, I do not remember.
I'm embarrassed you don't remember her. She was one of your union members. She alleged that she was the victim of sexual discrimination at one of your local unions. This is what she said. She alleged that one of the executives there asked her, quote, if she enjoyed rough sex and bondage. She said that the chapter president, Mr. Dave Regan, asked her, quote, does the carpet match the drapes? And, quote, what would you do for some jewelry? She alleged that Mr. Regan told another staffer, quote, that the only way she is getting a job is if she sucks my member of the male anatomy. Another employee said in an affidavit that Mr. Reagan, quote, went around asking women if he could sniff their panties, close quote, at an October 2017 work party. She said another executive, quote, grabbed my upper thigh while I was driving. And she wrote you and asked you to investigate. And you said no, didn't you?
Senator, I have dedicated my career to representing women and families. That has been my work.
You said no, didn't you?
Senator,
You told her that let her own chapter represent or investigate its own misconduct, didn't you?
Senator, I'm going to give you additional time, but I want the witness to be able to fully answer the question.
Senator, the letter that you are quoting from, I wrote in my capacity as counsel to my client. It was the position of my client, and I was acting as an advocate.
You refused to investigate, though, didn't you?
Senator, I believe that I have faithfully adhered to my obligations as an attorney for my client.
I don't think Ms. Sturgis would agree with you. In fact, Mr. Reagan, the chapter president, is still the president, isn't he?
I believe.
You don't even know?
Dave Reagan is the president of one of our local union, of one of SEIU's local unions, yes.
Wow. Mr. Mangy. I just want to be sure I understand your testimony, sir. And congratulations, by the way.
Thank you.
From 2019 to 2023, you were a board member of the Center for Security, Race, and Rights at Rutgers Law School. Is that right?
I was a member of an advisory board, Senator.
Right. Most boards advise, don't they?
Well, Senator, boards of directors govern an institution. Advisory boards do not have a governance role. They merely provide counsel.
Do you know of any boards that don't offer advice?
Well, they're different in their legal function.
Okay. Y'all held an event on the 20th anniversary of the 9/11 terrorist attack on America. You held an event on the 20th anniversary attack, 9/11 attack on America. And you invited as speakers. Your first speaker was Dr. Sami Al-Arian. He was convicted of conspiring to provide material support, convicted in a court, to the Palestinian Islamic Jihad. And the Islamic Jihad participated in the October 7th massacre and mass rape. Your second speaker was Dr. Rahab Abdulhadi, who has organized panels for the Popular Front for the Liberation of Palestine. One terrorist, Leila Khalad. Ms. Khalad hijacked planes. You invited her as a speaker, or her mentor as a speaker. The third speaker you invited, Mr. Hatim Bazilian, was the co-founder of Students for Justice in Palestine and has publicly called for an intifada in the United States. Is this the way you celebrate 9/11? Have I said anything that was inaccurate?
Yes, Senator.
Tell me.
Senator, my involvement with the center at Rutgers Law School, which is a preeminent law school in the state of New Jersey,
I can tell,
is on an advisory board that, when my role was limited to providing advice on academic areas of research, primarily through a meeting held once a year. With regard to the event that you are describing, I've never heard of that event prior to today. It was never presented to the advisory board that I was part of. I know nothing about it. I know nothing about the speakers. I've never heard of any of those people.
How can you sit on an organization that would invite these terrorists, convicted terrorists, Counselor?
Senator, it is an advisory...
You didn't resign.
Senator, I never heard of that event until today. It is an advisory board where my role...
So you just had an epiphany today?
Senator, your time has expired.
May I respond?
Would you like to complete your answer?
Yes. I have never heard of this event prior today. It had nothing to do with my role on an advisory board.
But you're on the board. Thank you, Mr. Chairman. Judge. Congratulations. Let me start with Judge Baggio. Am I saying that right?
Yes, sir. Thank you.
Judge, tell me about Title VI of the Civil Rights Act of 1964.
Title VI, I believe, Senator, is the provision of the Civil Rights Act of 1964, which prohibits the discrimination based on religious preferences, I believe. Oh, I'm sorry. May I strike that? I'm sorry, Senator. I was thinking of Title VII. Apologies. As you're well aware, I'm sure from my record, Senator, in my 18 years as a federal litigator, as well as my 4.5 years on the state court bench, I didn't have the opportunity to litigate issues related to Title VI of the Civil Rights Act. So apologies for the misstatement. And were I to be so fortunate to be confirmed, Senator, I would make sure with no uncertainty that I would be fully fluent in that issue were it to be presented to me on the bench.
Okay. Judge, is it Bisco?
It's Briscoe.
Briscoe, I apologize.
No problem.
Tell me about Title VI of the Civil Rights Act of 1964.
Senator, in my 17 years as a member of the bar and 5 years on the bench, I have not had the occasion to address Title VI in my career. However, if I am so fortunate to be confirmed as an Article III judge, I would certainly research and study to be prepared to address that issue, sir.
Judge Lund?
Thank you, Senator Kennedy. I cannot add anything that my panelists have not otherwise add. I can also assure you, though, in the 15 years that I've had the privilege to serve as a judge, that particular provision has not been put before me, but if it were to, I would faithfully review it and appropriately apply all Supreme Court, United States, and Seventh Circuit Court precedent that's put before me.
Well, Title VI is kind of timely, isn't it? I mean, I'm sure you all read the newspapers, right? Okay. Judge Baggio, where does the standing requirement come from?
Senator Kennedy, the standing requirement stems from the cases and controversies provision of Article III.
Okay, thank you for that. Judge Briscoe, I got it right this time. Tell me about the law of the case doctrine.
The law of the case doctrine is when a case has been adjudicated, then there cannot be any other collateral claims stemming from the issues that were already litigated.
Okay, thank you for that. Tell me about, Judge Lund, tell me about federal preemption.
Thank you, Senator, for that question. In just using the words in and of themselves, I would assume that that the phrase speaks for itself, that federal law would preempt anything else that would come before it. But again, if I were posed with that particular legal phrase, I would do all that I could to faithfully review what specifically it is about and faithfully apply that definition to whatever the situation was that was posed in front of me.
Well, where does federal preemption come from?
Well, federal preemption comes from the Supremacy Clause, that federal laws and the Constitution are supreme and state courts are required to uphold them.
And how do you know if there's federal preemption?
Again, I would look towards Article 6 of the Constitution, which again is the provision in which
You won't find it there. How do you know when federal preemption happens? You're going to see it a lot as a federal judge.
Thank you, Senator Kennedy. Again, I would be looking towards Supreme Court precedent, Seventh Circuit Court of Appeals precedent to review any of those particular issues that would come before the court and would faithfully apply them.
You don't know the rule for determining federal preemption?
I could not accurately articulate that today. Thank you.
Thank you, Mr. Chairman. Congratulations to each of you. Judge Meriwether, you've been nominated to the Court of Federal Claims, is that right?
Yes, Senator.
How many motions have you argued in the Court of Federal Claims?
I have argued hundreds of motions involving complex civil claims in numerous courts. The Court of Federal Claims is not one of those courts.
Okay, so the answer is 0?
That is correct, Senator.
Okay. How many cases have you tried in the Court of Federal Claims?
I have tried a civil case in the district court for the District of Columbia. Most of my cases have been resolved on motions. None of those cases have been in the Court of Federal Claims, although they involve similarly complex matters under civil laws.
So the answer is 0?
That is correct, Senator.
What is the, tell me the grounds for granting a new trial in the Court of Federal Claims?
All of the trials in the Court of Federal Claims are bench trials, and the Court of Federal Claims, although it is not bound by the federal rules of civil procedure, its rules mirror those rules when applicable. So it's my understanding that the same rules that would apply in the district court are also applied in that context. But if I were presented with a motion for a new trial, should I be confirmed as a judge on the Court of Federal Claims, I would, of course, consult the rules of court of the Court of Federal Claims.
So what are the grounds for granting a new trial?
My understanding is that a new trial, you would have to comply with the applicable rules.
I know that, but what are they? What are the grounds? You said that the rules are identical to the Court of Federal Claims and Federal District Court. I'm not sure that's accurate, but just tell me what are the grounds for granting a new trial in the Court of Federal Claims?
Senator, that is not an issue I have had occasion to consider before, despite my extensive civil experience and my familiarity, not only with the federal rules of civil procedure, but I've also reviewed the rules of the Court of Federal Claims. But if I were presented...
I'm sorry. Go ahead. No, you go ahead. You go ahead. Were you through?
I did not mean to speak over you.
That's okay. You go ahead, and I want you to finish your answer.
So I would, if I were presented with that question, should I be confirmed, I would, again, consult the rules and follow the precedent.
All right. Let me be sure, Judge, I understand your testimony. Can you tell me one single ground for granting a new trial in either a federal district court or the Court of Federal Claims, as we sit here today?
Yes, if you misapplied, if there were gross misapplication of the law, certainly a litigant would argue for
Anything
a new
else?
trial.
There are like 6 or 7 of them. Can you tell me any others?
Trials are so infrequent in the civil context, and although I have presided over bench trials and a jury trial, I have not been presented with a motion to have a new trial.
Okay.
So I've not,
Okay. What's a contract of adhesion?
a contract,
Excuse me.
Senator, I'm familiar with contract law, the concept of contracts of adhesion.
Yeah, you're going to say a lot of that. That's what Court of Federal Claims does. What's a contract of adhesion?
Senator, the Court of Federal Claims does handle a lot of procurement cases. Those typically turn on interpretations.
Yes, ma'am, but I'm going to run out of time. What's a contract of adhesion? If you don't know, just tell me.
Senator, despite my extensive civil experience, including dozens of cases that include contract cases, I have not dealt with the question of what a contract of adhesion is, but should it be presented to me, I
Sure,
would.
you'll look it up. Okay. Do you remember a case, Judge, called United States v. Allen?
Yes, Senator.
You were reversed in that case, weren't you?
I made a pretrial detention decision for, I believe, 5 defendants. I believe that Mr. Allen was one of the defendants for whom the district judge disagreed.
Yes, ma'am.
with
But you were reversed.
My pretrial detention ruling, I believe, was.
Do you remember a case called United States v. Johnson?
I have had multiple United States v. Johnsons. Are you referring to the pretrial detention
Well,
matter?
in this case, you had a defendant who was charged with traveling with intent to engage in illegal sexual conduct with a kid. And the defendant also testified that he had, quote, had a sexual interest in minors and even had a sexual relationship with his daughter. You remember it now?
Yes, Senator.
Okay. And you were reversed in that case, weren't you?
I made a narrow decision in Johnston that he should be released for 21 days
Yeah.
so that he could, and placed on home incarceration
Right.
so that he could get cancer treatment that he had been unable
You
to
wanted
receive.
to let him go out for 21 days. Is that correct?
I don't think that's an accurate characterization.
Well, that's what the district court judge said.
The district
court said, no way am I letting this guy out on the street for 21 days.
The district court judge concluded that his life was not at risk because he had had the medical appointment that he had not had when he appeared before me before the appeal. So under those new facts, the factual predicate for my temporary release decision no longer existed.
That's not the way I read it, Judge. Do you remember a case called United States v. Voucher and United States v. Patel? You were reversed in those cases, too, from trying to let somebody go, weren't you?
In those 2 cases, my flight risk assessment under the Bail Reform Act, I believe, was reversed by the district judge.
Okay, I'm out of time. Thanks, Mr. Chairman, for your indulgence. Congratulations to all of you. Judge Dubose, am I saying your name right?
That's correct, Senator.
Okay. We don't have a lot of time, so I'm going to be direct. I think most of my questions are designed to be yes or no. Are you still a Marxist?
Thank you for the question, Senator.
You don't have to thank me. We'll say you are welcome.
I am not, nor have ever been a Marxist.
Well, you gave an interview in 2000 to the Feminist Press. In fact, you didn't turn it over to us. We had to ask for it. We found it on our own. And you did then turn it over to us. And this is what you were describing your time working in a coffee shop. You said, quote, the kids would come into the cafe all the time. We'd talk about what they're doing. We'd talk about their classes. And I was in my Marxist phase. So you used to be a Marxist, but you're not now?
No, Senator, if I may, the context of that interview, I had no idea that interview was something that was going to be published. I did an interview with it
Did you mean what you said, whether it was published or not, or whether we'd find it? Trying to understand what you believe. You said I was in my Marxist phase.
Thank you, Senator.
Still in your Marxist phase, or was that in the past?
No, Senator, if I may explain.
Sure.
I was a political science major. When I graduated from college, I immersed myself in a ton of political theory. I read Hobbes, I read Locke, I read Rousseau, I read Marx. I went through a phase where I was into Eastern religion, where I read the Tao Te Ching, the Analects of Confucius. So I suspect, and I don't know that quote with the article, I don't know if she was referring to what I was studying at the time, but as a political science major and as a theorist and someone who was considering teaching a course in political theory, I immersed myself in those things.
But she didn't refer to anything. She meaning, I assume you're referring to the reporter who interviewed. These are your words, and you didn't say I'm in my Hobbes phase. You didn't say, second, I'm in my Locke phase. You didn't say I'm in my Rousseau phase. You said I was in my Marxist phase, and my question is real simple. Are you still a Marxist?
Senator, I've never been a Marxist, and I'm not a Marxist today.
Okay. All right. Have you ever served as lead counsel in a federal bench trial?
No, Senator. With my experience as both a state prosecutor, as an in-house counsel at Schneider Electric, doing very complex compliance and regulatory work, and my work as a district court sitting judge, handling general jurisdiction.
Yes, ma'am. I've read your resume. I just want to get through these questions. Have you ever served as lead counsel in a federal jury trial?
No, Senator, I have not.
Okay. Have you ever attended a federal jury trial? And
No,
watched
Senator.
it live?
No. No, Senator.
Have you ever watched a federal jury trial on TV?
I don't believe that federal trials are televised, so no, I have not, Senator.
Have you ever watched any trial on television?
Senator, I handle and preside over trials every single day as a state district court judge. We follow the rules of evidence, criminal procedure, civil procedure. So I feel that with my experience, that I am well suited and capable to make the transition from our state district court to our U.S. District Court.
Okay. When you were practicing law, did you ever draft a motion or a brief applying the federal rules of evidence?
No, Senator. As a state prosecutor...
I'm sorry, you said what?
I said no, Senator.
No, okay. When you were practicing law, did you ever draft a motion or a brief applying the federal rules of civil procedure?
Well, I believe that there were times at Schneider Electric giving advice to business units regarding the federal acquisition regulations, that I would draft briefs to give them counsel as to how to be compliant with the federal rules. So in that respect, the answer would be yes.
Okay. What's an interpleader action?
Interpleader action is a third party who's going to intervene in a civil suit. They're not a primary party.
Okay. What's voir dire?
Voir dire is the process with which jurors are questioned by the state and by defense and prosecutors to serve on a
Have
panel.
you ever conducted a voir dire in federal court?
Not in federal court.
Okay. I'm going to yield back 6 seconds, Mr. Chairman.
Thank you. Senator Whitehouse.
Just to clarify the record, Judge Dubose, do you recall when that interview was done, the interview that Senator Kennedy referred to?
No, Senator, I don't. And if I recall, and I was brought to my attention yesterday, that was never an interview that I did I thought was going to be published. I never reviewed it. I didn't. It was an undergrad student who was interested in teaching, who spent 20 minutes.
What were you doing at the time?
I was teaching.
So this was before you even went to law school. This was
Yeah, I was really early.
many years ago.
It was, Senator.
Perhaps during the time when my colleague Senator Kennedy was a Democrat, showing that people can change their views, even if it were true that you were then in a Marxist phase.
Senator Graham.
Mr. Chairman, my name was invoked.
I noticed.
As a proud Democrat, we were like that
My
part
name
of your
was
history.
invoked, Mr. Chairman. Now, I just want to let the record reflect, and I love Senator Whitehouse.
Uh-oh.
But I'll tell you one thing, I've never been a Marxist. I've never been a Marxist. And I've never admitted I was a Marxist and then not turned the document over to this committee. We had to find it. And we did. And now the testimony under oath today is, I didn't say that. The reporter said that. No, the witness said that. And then the testimony is, well, I didn't mean it to become public. That's not the issue. So, you know, if we won't get personal here, we can.
Senator Graham?
Thank you. Let's agree on the following. A Louisiana Democrat's probably not a Marxist.
Thank you, Mr. Chairman. Judge Coggins, you used to work for Governor Jerry Brown,
That is correct, Senator.
and I believe you advised him on issues regarding parole.
So as the governor under the California Constitution, when the parole board recommends that a inmate be paroled, that matter then comes before the governor to determine whether he's going to reverse that recommendation.
Did you advise him on parole?
I was not advising him. What I provided was a background, all background information. So the nature and circumstances of the particular case that was before us. I was looking at the correctional file. In addition, I was reviewing.
Do you remember a parolee named James Schoenfeld?
I don't, Senator.
Okay. You talked a lot about, as did you all appropriately, about juveniles in your testimony. Governor Brown in 2015 paroled Mr. James Schoenfeld. He was convicted of kidnapping 26 kids, juveniles, and burying them alive. Were you with Governor Brown then?
I left in 2015, so I'm unsure of the time period in which that occurred.
This happened in 2015.
That name is not familiar to me. What I can say is those decisions are.
Do you remember the case?
I do not.
Okay. When it happened, it got a lot of publicity in California. Did you call Judge Brown or Governor Brown and say, Governor, I love you, but what planet did you just parachute in from? Why have you done this?
I did not.
Do you agree with this decision?
I would need to look at the file. I don't know the context. I don't know the background, the insight, and the decision that Governor Brown would make is whether the parolee is poses an unreasonable risk to the safety of the community. And
Do you think kidnapping 26 juveniles and burying them alive presents a risk to the community?
I certainly believe that if that individual is convicted of those crimes, which it sounds like he would be a risk to the community.
But you don't have an opinion about whether Governor Brown did the right thing?
Again, Senator, I would have to be able to look at the complete file and all of the considerations required of the governor, who ultimately makes the decision.
So he might have done the right thing, in your opinion?
I would want to look at the complete file in order to make an assessment.
All right, Judge Bosara. Do you remember a case called J&J Sports Products v. If I mispronounce it, sir, please correct me. Ferraris?
I do recall that case, Senator, yes.
Okay, it was pretty recent, 2020. You're a magistrate judge, right?
I am.
And your decisions have to be reviewed by a federal district court judge?
That's correct.
Okay. You made a ruling in that case, and the district court reversed you.
In part, yes.
And the district court said, quote, these are the judge's words, not mine, that you ignored, quote, a large collection of cases in this district holding that essentially identical allegations are sufficient to state a claim. So your boss said you just ignored a whole line of cases. What's going on here?
Well, Senator Kennedy, the way I recall that case was there's a split in authority about claims that can be brought under the Copyright Act. And there were, in addition to the cases that the district judge cited, there was a whole bevy of other cases going in the other direction. And the Court of Appeals had not ruled on it.
Yeah.
And
But the judge didn't say you looked at both line of cases and decided one was more accurate than the other. He said you totally ignored a line of cases. Did you just disagree with those line of cases?
Senator, I would never ignore a whole line of cases, and I know that was a very lengthy opinion that I issued, and it's my practice in the 1,000 opinions.
Well, I'm going to run out of time. I'm sorry to cut you off, Judge. I don't mean any disrespect. The district court judge says you ignored those cases.
I would respectfully say, as I don't...
Was he wrong?
I'm not going to call a colleague wrong, but I can say that in every case where I write a lengthy opinion, I read all of the applicable authorities. And I know in that particular situation, there's a line of other cases that I have read, and I did so in all of my decisions, and I can expect that I did so in that one as well.
But why did you ignore the line of cases, is my point. I can understand you saying, well, there are two line of cases and they conflict, and I find the reasoning more persuasive in this line. The district judge reversed you, said you just totally ignored them. That worries me.
He reversed me only in part, Senator, and in those line of cases, I think there's a split of authority at the district court level. There's no governing Court of Appeals decision or a U.S. Supreme Court decision, which my oath requires me to follow.
Okay. Thank you, folks. Judge, welcome.
Thank you.
You are probably the least productive member of your district court, isn't that right?
Well, I have not considered myself in those terms, Senator.
Well, let me explain what I mean. You have 125 motions pending that you've declined to decide.
Well,
let me finish. That's more than any other district judge in the entire Seventh Circuit. In fact, you rank 7th highest nationally, do you not?
I am not familiar with those statistics, Senator Kennedy.
You haven't looked?
I did look in preparation for this hearing, but I didn't compare myself to others.
You haven't seen that you ranked the 7th the worst in the country in terms of making decisions?
You are the first to tell me this. And I think for me, I stress the quality of my decision making. And as I explained, I came on, I was the first district judge to come on during this administration.
Yeah, but so were all the others. I mean, there have been 68 district judges confirmed in the 117th Congress. In terms of motions pending for more than 6 months, you rank number 3. You all came on at the same time. You all had the same problems with COVID. You're the 3rd worst. You really think of all the other district judges in the 7th Circuit, you're the one that ought to be promoted based on this record?
Senator, this is something that I've discussed with my fellow judges. Many of us new judges from...
Not you said you'd never looked at these statistics.
I haven't, these particular statistics I am not familiar with. But in terms of new judges, both from the current administration and the former administration, we are quite a collegial bunch. And oftentimes talk about the pressures of a new judge and the way reassignments work in our district, which is that you get, for example, 300 cases.
Yes, ma'am, I understand. I'm familiar with the procedure in federal court. Here's what I'm trying to understand. Why is your record so bad?
Well, I don't view it that way, Senator. When I look at the quality of my decision-making The feedback that I get from parties,
Well, of course, parties are not going to criticize you. They want you to rule in their favor.
I understand, Senator Kennedy.
I mean, that's just the way it works. Help me understand why you have such an abysmal record in moving cases. I mean, it costs a lot of money to litigate, and people are paying lawyers, and time is money. And of all the district court judges in the Seventh Circuit, you're the worst in terms of moving cases. Why do you think you deserve to be promoted over all of those others?
So, Senator, again, I'm not familiar with the statistics, but I stand by my record and that I give parties what they need. I think, I am regularly in my courtroom. I am regularly issuing decisions. I just came on at a very difficult time where there was a backlog in the courts.
So did everybody else. Let me ask you, when you were a partner in your law firm, you volunteered to write a brief on behalf of the Brady Center. You wrote the brief, and this is what you said. You volunteered for this. You weren't being paid. Is that right?
This was a pro bono case that one of my partners brought in, yes.
You said, quote, assault weapons may be banned because they're extraordinarily dangerous and are not appropriate for legitimate self-defense purposes, close quote. Tell me what you meant by assault weapons.
Thank you, Senator Kennedy. Just to clarify there, I was local counsel. Our Supreme...
but you wrote the brief. Tell me what you meant by assault weapons.
Senator Kennedy, actually, I did not write the brief. The brief was written by...
You signed the brief, though, didn't you?
Correct. I signed the brief.
When you sign a brief, you're testifying to the court that everything in it is true, right?
Yes.
Okay. So they're your words in terms of the court, right?
Well, you're correct, Senator Kennedy. Okay. I would never sign...
Tell me what you meant by assault weapons.
So I am not a gun expert, and at the time, that brief, I think, was about 10 years...
You were giving the court advice about, say, ban assault weapons. What is... You told the court you were an expert. Just tell me what you wanted to ban.
Senator, sitting here today, as I said, I did not write that brief. I was local counsel.
Sign the brief.
I understand. At the time...
Tell me what you wanted to ban. That's all I want to know, Judge.
I don't remember the exact definition of assault weapons in the ordinance that was at issue.
So you submitted a brief to an appellate brief, you signed it, and you don't know what, and you said abolish assault weapons, and you don't know what you wanted them to abolish?
Senator, at the time that I signed the brief, I read the brief because our Supreme Court required an Illinois bar member to sign the brief. I was not responsible for researching the content.
You were responsible for the brief.
Absolutely, absolutely. And sitting here today, I do not remember the characteristics that were cited in the ordinance for the assault weapons ban. It's not an area of practice that I have specialized in. I'm sure 10 years ago I could have answered your question.
And
but
Judge,
sitting here today,
you think you deserve to be promoted? With this record?
Senator, I stand by my record. I stand by my record.
Thank you, Mr. Chairman. Congratulations to all of you. Judge Martinez, tell me about state police power.
Senator, my understanding of state police power is the authority of the state officials to enforce state law.
Well, what if the state law is in violation of federal law?
Well, we have the Supremacy Clause under Article 6 of the Constitution that provides that federal law is the supreme law of the land.
Yeah, but that's not an exercise of state power. What's the origin of states' police power?
My understanding, Senator, is also from Article 1 of the Constitution, where the Congress was enumerated certain powers, and under one of the provisions of Article 1, anything that was not specifically enumerated.
You don't think it's Article 10?
Well, Article 10 has to also, is also applicable.
Actually, the 10th Amendment, what does the 10th Amendment say?
The 10th Amendment provides that any specific power that was not given to a Congress or denied to the states applies to the states and the people.
And that's the origin of a state's police power, right?
Yes, Senator.
Okay, it's not Article 1.
I read it as both, Senator, but if it's Amendment 10, then it's Amendment 10, Senator.
Does the federal government have police power?
The federal government has authority to enforce its federal law.
Yes, ma'am. But we've talked about the state's police power. Does the federal government have police power?
Well, the executive branch has the power to enforce the law executed by the legislature.
Well, but the federal government can't. The Constitution's pretty clear that you have to have an enumerated power in the Constitution, right, in order to be able to do something?
Well, it's my understanding, Senator, there are enumerated powers, but there are also implied powers in the Constitution.
Yeah, but those are implied to be enumerated. There is no federal police power, is there?
Well, Senator, my understanding is that the executive branch has the power to execute the laws of the United States.
I know, but that has nothing to do with police power. Let me move on. Counselor, tell me how to say your last name.
Suknanan, Senator.
Say it again, please, ma'am.
Suknanan.
Suknan?
Suknanan.
Suknanan, okay. Counselor, you used to practice law at Jones Day, is that right?
That's correct, Senator.
Okay. And there was an article in the New York Times. I don't know whether you leaked it to them or somebody from your law firm leaked it to them. Your firm, Jones Day, you were a partner then, and you were representing a party, your firm was, and you were, in a post-election challenge to Pennsylvania, the Pennsylvania Supreme Court. The Pennsylvania Supreme Court, of course, extended the filing deadline for absentee ballots in the president's election, and that was challenged as being unconstitutional under both the state and the federal constitution. Am I right?
Yes, Senator.
And Jones Day was handling that case, right?
That's correct.
And you were a partner at Jones Day, is that right?
That's correct, Senator.
Okay. And who was your client in that case?
The firm's client was the Pennsylvania GOP, Senator.
Well, it's your client too, right?
Correct, Senator. I was not the lawyer in that case, but yes, Senator.
But you were going to share in the profits made from the bills paid by the Pennsylvania GOP, right?
Senator, it was a firm client. I was a partner at the firm.
And you were going to share in the money, right?
Correct, Senator.
Okay. And in a call where you and some of your partners were talking about the case, this is what you said about your client who's paying you. You said, this is according to an August 25, 2022 article. You said, quote, "This lawsuit was brought for no other reason than to deprive poor people of the right to vote," close quote. You said that, didn't you?
Senator, those were not my words. I do not know who provided that quote to the reporter.
You gave it to the reporter, didn't you?
Senator, I never spoke to the reporter or anyone in the media about the meeting in question, and I'll tell you why. As a partner at Jones Day, all partners are bound by a confidentiality obligation to the firm. And that meeting was an internal confidential partners meeting.
Yeah,
I never spoke to the media about it, and those were not my words, Senator.
This is a violation of about 927 provisions of the Code of Ethics, isn't it?
Senator, that's why I never spoke to that reporter, and those were not my words. I do not know who provided that quote to the reporter.
What did you mean? Who was trying to deprive poor people of the right to vote? Who were you referring to when you said that?
Senator, as I said, those were not my words.
Oh, you never said that. You denied.
Senator, those were not my
So
words.
if we
and-
deposed your partners on that call, they would say, no, she never said it.
Senator, I am telling you here today under oath that those were not my words. I never spoke to
We
them.
deposed your partners on, and put them under oath. They would say, no, she never said that.
Senator, I can't tell you what someone else would say under oath. I can tell you under oath that those were not my words. I never spoke to the media about that call.
And you think in light of this, you're qualified to be a federal judge?
Senator, I never spoke to the
Say
media.
that about a client?
Senator, as I said, those were not my words, and I never spoke to the media about the meeting in question. I take my obligations, ethical and otherwise, incredibly
Counsel,
seriously.
you said that, didn't you?
Senator, I did not say those words.
So the New York Times got it wrong? Thank you, Mr. Chairman. Mr. Ritz, you are a political activist, aren't you?
I would not consider myself that at all, Senator.
Okay. When you were sworn in as U.S. Attorney, you gave a speech, didn't you?
I did.
Okay. Here's what you said. I'm going to quote from your speech. But you should know that justice for me is about more than putting people in prison. For me, it's also about who votes and how hard it is to cast that vote. It's about where pipelines go. It's about where bus routes go. Justice is about whether people in all zip codes can get along, whether women have access to health care, whether citizens have affordable housing or clean drinking water. Sometimes those are Department of Justice issues. Sometimes they are not. But for me, they're all justice issues. Did I read that accurately?
I believe so, Senator.
Okay. Did you really remove the Tennessee state flag from your conference room?
Senator, I appreciate you asking about this again. As the chief federal law enforcement.
Welcome. Did you do it?
So I felt it was fundamentally inappropriate when I gave press conferences and similar statements to the public to indicate or suggest somehow that I spoke for the state, which I don't under our system of federalism.
Are you embarrassed to be from Tennessee?
Not at all, Senator. I am from Tennessee, grew up as a public school kid in Tennessee.
But you were embarrassed to have the Tennessee flag.
That's not it at all, Senator.
Okay. You have a history of lying to your professional colleagues, don't you?
That's not true, Senator.
Okay. Do you know a former public defender named Stephen Shankman?
I knew him to a degree. I'm not sure we ever had any cases together. I knew who he was, yes.
Well, in a private email, not meant for public consumption, to another one of your professional colleagues, this is what Mr. Shankman said, talking about your lying. He said, "It is unfortunate that this is not the first, second, third, or whatever occasion that this sort of thing has occurred. But everyone should be aware of this unfortunate pattern of behavior. You should be aware," he said to the other lawyer, before the other lawyer dealt with you. "Your client should be aware, and you should proceed with extreme caution." Was Mr. Shankman lying?
To the degree he suggested that I acted unethically, that was not accurate, and it wasn't in any occasion, much less on numerous occasions.
Okay, let's talk about this case, United States v. Von Rico Weber, which you claim to not remember. But before I do that, a few seconds ago, you lied to Senator Hawley, didn't you?
I'm under oath, Senator. I did not lie.
You said you have no knowledge of any complaint, professional complaint made against you, didn't you?
I said I have no knowledge of any sort of formal complaint, and he read from a letter that I don't believe I ever saw.
And you were shocked. You
If
never heard of that before.
If there were a formal complaint, that, as I said, I had not known about that.
Okay. You were amazed.
I don't recall any of that.
Any.
I recall this Mr. Weber's
You have
case.
amnesia about it.
Again, I am unaware of any formal complaint or investigation. Certainly was not.
You believe in the Tooth Fairy?
Senator, I don't.
You believe in the Easter Bunny? Now, in this case, United States v. Von Rico Weber, you lied to the defense counsel. And the defense counsel then had to go before the court and withdraw a plea for his counsel. And a complaint was filed, about which you apparently have amnesia. And the Justice Department replaced you. And the lawyer from the Justice Department who replaced you, this is what the lawyer said. The new attorney said about you. Said these allegations against Mr. Ritz are, quote, serious. And it is taken so seriously, referring to the Department of Justice, by our office. That is one of the reasons I'm here, and Mr. Ritz will be more than likely be taken off this case because of those allegations. End quote. You lied to Senator Hawley, didn't you?
I didn't lie to the defense counsel in that case. I didn't lie today, Senator.
Now, my good friend Senator Ossoff asked you if you'd follow the law. And you said, yeah. But if you're lying to us today, we're stuck with you, aren't we?
Senator, I have not lied and did not lie in that case.
You just have amnesia.
I did not lie in that case. There was a written plea agreement with the entire agreement of the parties.
If you believe that, you believe Elvis is alive and running a small bait stand on Lake Erie. Shame on you. Thank you, Mr. Chairman, and congratulations to all three of you. Judge Pinnell, you are a political activist, aren't you?
Thank you, Senator Kennedy. I am a judge on the Washington State Court of Appeals. I don't consider that to be a political activist.
Okay. In 2020, you and 10 of your friends issued a written statement. You entitled it, quote, Statement on Racism, White Supremacy, and Justice. Here's what you said. I'm quoting from you now. Racism and white supremacy currently plague every social, educational, economic, governmental, and legal system. Racism and white supremacy currently plague every social, educational, economic, governmental, and legal system in our state and in our nation. And they have for centuries. Both, you're referring to your state and America, both target Black, Indigenous, African American, Latinx, and other people and communities of color, resulting in entrenched inequality and inequity, manifesting in unjust, unfair, and differential treatment, and yielding remarkably disparate and negative outcomes relative to those experienced by white people. End quote. Did I read that accurately?
Senator, I don't have it in front of me. I don't have any reason to think that you did not read that correctly.
Okay. You are very active in Planned Parenthood, are you not?
No, Senator.
Okay. Well, Planned Parenthood, in its annual reports, lists you as a, quote, silver friend, close quote. Do you know what a silver friend means?
I don't, Senator.
That's someone who has donated between $1,000 and $2,500 to Planned Parenthood of Greater Washington and North Idaho. That's in the Planned Parenthood annual reports. You don't know anything about that?
I don't recall. What I recall, Senator, is that my husband had donated to Planned Parenthood, and I think at some point in time they listed me along with him, but I believe that was a donation.
This is you.
Okay.
And in fact, they say that as of 2018, you've been a donor for at least 10 consecutive years. Is that right?
I do not recall donating them for the last 10 consecutive, 10 years before 2018 or 10?
That's as of.
I don't recall, Senator.
Okay, you don't remember. Okay, let me ask you, you're on the Court of Appeal. Let me ask you about a few of your cases. Do you remember a case called State v. Westwood?
I believe so, Senator.
And you were reversed in that case, weren't you?
Senator, in reviewing my cases, I think I've been reversed in about 2% of the cases that I've issued. I've issued almost...
Were you reversed in that case, though?
That was a very complicated case regarding sentencing
But I'm
law.
going to run out of time, and I got a bunch of these.
Okay.
Were you reversed?
That might have been one of the 2% of the cases. I think so.
reversed?
I believe that was one of the 2% of cases,
You remember
Senator.
a case called Personal Restraint of Heiress?
That, I think, was the case regarding whether or not the person had been
Were you
deprived.
reversed in that case?
That was, I think I was not
Were you
reversed.
reversed in that case, counsel?
Senator, I think that I wasn't reversed as to outcome, but it was one of the 2% of the cases where the state Supreme Court
Do you
disagreed with the
remember a
analysis.
case called Parental Rights of ALK? Were you reversed in that case?
Senator, I think that was one of the 2% of my over 450 cases where there was a reversal.
Do you remember a case called State v. Log Bomb?
I recall that case, Senator. That case.
Were you reversed in that case?
That was one of the 2% of cases. I issued an opinion to affirm a conviction, and the state Supreme Court overruled that
You
and
remember
reversed.
a case called State v. Barboza v. Cortez? Were you reversed in that case?
Senator, that case is not coming to mind. Again, I've issued over myself personally written over 450
You remember
decisions.
a case called State v. Telvik?
Senator, I think I recall that name. That might have been one of the 2% of
reversed
cases.
in that too?
That might have been one of the 2% of cases,
Okay.
Senator.
Another case, Hendrickson v. Moses Lake School. Were you reversed in that case?
Senator, I recall that case. I think that might have been one of the 2% of cases where the state Supreme Court disagreed with the analysis of another appellate
Were you
court. from the
reversed?
state.
You remember a case called State v. Curry? Were you reversed there?
Senator, I think you're reading off all the cases. I think that's one of the 2% of cases.
Okay. How about a case called State v. Rathbone? Were you reversed?
That's probably one of the 2%, Senator.
How about a case called Douglas v. Shamrock Paving Company?
Senator, that's a case where I was largely affirmed. The only thing that was a reversed, I included everything, even if it was just a partial reverse. The only thing that I was reversed on was an award of attorney fees. The substance of the law, which was rather new in that case regarding what constituted an investigation for an environmental
So
cleanup.
you weren't reversed?
That part of it I was affirmed.
Yeah, I think that would be a surprise to the Supreme Court that you weren't reversed.
Okay, thank you, Senator.
I'm out of time. Thanks, Mr. Chairman, for
Senator.
your indulgence. Thank you, Madam Chair. Judge Dixon, can you tell me about the full faith and credit clause of the Constitution?
It's me, Senator Kennedy, Judge
No,
Valenzuela.
I'm sorry. I can't see that far. I just got new glasses. Judge down here, and then we'll come this way.
Judge Court, Senator, I had the same issue when I walked into the room. I thought that it would be difficult to see my last name, so no need to apologize.
Okay.
So, and I apologize. Your question is the full faith and credit
clause, yes, ma'am.
clause of the Constitution. It requires that the states give full faith and credit to judgments of other states.
Okay, very good. Judge Netburn, I was looking at your resume. You went to Brown University, is that right?
I did.
And then you went to law school in California?
That's correct.
And you've worked for the Brennan Center
I interned. I was a law student intern.
Okay. And you worked for the Center for Reproductive Law and Policy?
I was a law student intern there for 8 weeks during my 1L summer.
Okay. And you are a political activist, aren't you?
I am not. I'm a sitting United States magistrate judge.
Okay. All right. Do you remember an inmate named William McLean, also known as July Justine Shelby?
Yes, I know who you're referring to.
Okay. Mr. McLean raped a child, didn't he?
30 years ago, the petitioner in the habeas case before me.
Did he rape a child?
He pled guilty to that crime. Yes, it's abhorrent.
And then he raped he raped a little boy, right?
I believe that's correct. I believe he pled guilty to 2 acts of sexual violence.
And then he raped a 17-year-old girl, right?
Again, this case was handled by the state court in Indiana, but I believe...
I'm just asking you the facts. Don't stall on me now. Did he rape a 17-year-old girl or not after raping a 9-year-old boy?
I believe that's what he pled guilty to.
Okay, and then he went to prison, didn't he?
Yes, the petitioner was...
And then he came out and he sent child porn, basically adults raping little children, to another sex offender. And he was sent back to prison, right?
The petitioner pled guilty to...
Was he sent back to prison?
Well, that case was in the federal system, so...
Was he sent back to prison?
Yes, this time to federal prison.
Thank you. And then he decided to transition, and he became a female and started going by July Justine Shelby. Is that right?
Yes.
And Ms. Shelby said, I don't want to go to a male prison. I want to go to a female prison. And the Board of Prisons said, what planet did you parachute in from? You're going to a male prison with this kind of record. And you sent him to a female prison, didn't you? You said that the Board of Prisons was trying to violate Ms. Shelby, former Mr. McLean's constitutional rights, didn't you?
I issued a report and recommendation to the district judge recommending that the district judge transfer the petitioner to a women's facility. The district judge adopted that recommendation.
The Board of Prisons was trying to violate Ms. Shelby's, Mr. McLean's constitutional rights, didn't you?
So I based my decision on the facts that were presented to me in the record evidence.
But it wasn't that your ruling?
I recommended finding that under Estelle versus Gamble.
Why won't you admit that was your ruling? Are you ashamed of it today?
I'm not. I'm answering the question. I applied Estelle versus Gamble.
But was that your ruling?
My recommendation was that the petitioner's serious medical needs were being denied by keeping her in a men's facility.
A violation of the Eighth Amendment, right?
That's correct.
Okay. And how big was Ms. Shelby, Mr. McLean?
I don't have a specific recollection. Your colleague just suggested that she was more than 6 feet tall.
And you told the Board of Prisons, well, she'll be okay. The other women in the female prison will be okay because it's only hypothetical that Ms. Shelby, Mr. McLean would reoffend again after he's already raped a 9-year-old boy and a 17-year-old girl and has been sending child porn through the mail. You said there's no chance he'll reoffend again. Did you say that?
Senator Kennedy, I based my decision on the record.
But am I right? Did you conclude that?
I don't have a specific recollection of that. I did recommend that after finding a constitutional violation.
What were you thinking in saying it's only hypothetical that she would reoffend?
The facts of the case were that the petitioner had last engaged in a contact offense 30 years ago. The petitioner had not engaged in any contact offense. In addition, the medical evidence made clear that for the last 5 years, the petitioner was sober and hormonally entirely a female, and there was no evidence.
The Board of Prisons didn't agree with you. I'm not going to run out of time here. You're really a political activist, aren't you?
I'm not, sir.
But your record demonstrates otherwise.
I disagree. I apply the law to the facts and come to a fair decision. All of my decisions that have been appealed, particularly this one, the district judge adopted my report and recommendation in full, and the government did not move for a stay of the decision.
Thank you, Mr. Chairman. Congratulations, Judge. I just want to talk a little bit about the law. Tell me about the war powers clauses in Articles 1 and 2.
Well, Senator, my understanding of the war powers is that the executive maintains significant authority with regard to the war, but that it has to be authorized by Congress.
What do you mean authorized?
Senator, I don't have a more, that issue has not come before me, sure. But I don't have a more specific definition of authorization than that the Congress has to, it's up to the Congress to, to authorize it. I can't say more than that, Senator.
Okay. All right, let's talk about another issue you'll see if you're confirmed with the 11th Circuit. It's an issue we struggle with every day, and as do the federal courts. Tell me about the non-delegation doctrine.
My understanding, Senator, of the non-delegation doctrine is that Congress should not delegate its powers to other branches of government except in certain limited circumstances.
And what are those limited circumstances?
I believe, based on my understanding, that Congress can, for instance, delegate some of its authority to the executive, such as executive agencies, if that authority is carefully circumscribed.
I'm not following you. The Constitution's pretty clear in Article 1 that the legislative power resides in the United States Congress, and we can't give it away. But your argument is that we can.
Senator, it's my understanding that in certain limited circumstances that are carefully circumscribed, that Congress can delegate some of its authority to.
Okay. What's the guiding principle, though? If we tomorrow, if Congress passed a law and said we're no longer going to confirm judges, we're going to set up a special agency within the executive branch and give that agency the authority to confirm judges. Somebody's going to litigate it. What would be the principle that the court would follow?
Senator, I would certainly, if that issue were to come before me on the 11th Circuit, if I'm fortunate to be confirmed, I would research the Supreme Court's precedent and guidance on that issue and any binding 11th Circuit precedent on the issue, if there is any, and address that issue. But in terms of the hypothetical situation, Senator, I would leave it at that.
Okay. Well, let me ask you this. Let's set aside what the principle is for a moment. The Supreme Court has been pretty clear what the principle is. Goes back, I don't know, 80 years. But let's suppose, well, strike that. What I'm trying to understand is how you think, Judge. What do you think the principle ought to be? I mean, our founders were very clear that the legislative power is ours, and clearly we've given away that legislative power in some instances to some administrative agencies. What do you think the principle ought to be? Could the Congress just come in one week and said, we're tired, let's just give it all to the president for about 6 months while we go fishing? Would that be constitutional?
Well, certainly, Senator, I think to that extent, would unlikely be constitutional based
Why do you think?
based on the principle that I just stated, that and that you have reiterated, that
Which is?
that Congress cannot delegate its authority except in certain circumstances.
And those are?
And those are ones that, Senator, I would not want to speculate about. I can say that I would follow the Supreme Court's guidance on that, and my understanding of that guidance is that those circumstances are very narrow.
Okay. But you're not familiar with the principle?
Senator, to the extent that you're looking for a specific articulation,
Yes.
I would have to look at the case law and follow up
Okay.
on that.
Robert, do you have any questions you want me to ask your dad? You sure? Now's your shot, man. Do you have anything you'd like to say to us, Robert? It's okay. A wise man once said nothing.
I think he had a hello for
A
you.
wise man once said nothing. Thank you, Judge. Thank you, Mr. Chairman. Congratulations to each of you. Judge Saporito,
Yes.
you and Senator Casey went to high school together?
Yes, we did, Senator.
Did you ever see Senator Casey try to sneak a beer past Jesus in high school?
I never saw that, Senator.
Oh, okay. Wise answer. Judge Vaca, you are a member of an organization called the National Association Pacific American Bar Association, are you not?
I was, Senator. My membership lapsed at the beginning of this year, but I was a member for 2 years.
Well, my record shows you were a member for 22 years.
Senator, that was a mistake, and I actually sent a letter after I saw that mistake to the committee, so it was 2 years.
Okay. And I'll call it the NAP ABA, is that the correct acronym?
I think NAPABA.
NAPABA?
Yes.
Okay, thank you. And NAPABA is funded by Mr. George Soros, is it not?
Senator, I'm not familiar with the funding. I was a member and I paid the dues, but I had no contact with any of the members there, and so that's why I let my membership lapse.
Well, its website says that it's funded by the Open Society Foundations, which are founded by Mr. George Soros. Now, NAPABA in March of 2023, while you were still a member, NAPABA issued a statement, and it said that it supports allowing transgender and intersex girls and women to participate in all sports. Is that correct?
Senator, I'm not familiar with NAPABA's statement, so I'll take your word for it.
You didn't know anything about that?
No, Senator, I joined the organization because I thought it would give me a community of other Asian American attorneys and judges, but I didn't have any interaction with anyone in the group. I didn't attend any meetings or vote, and so I'm not aware of that statement or any of other statements made by NAPABA.
So this is all an epiphany to you. Is that right?
Yes, Senator.
Okay. NAPABA also issued a statement that said the following. It supports state and local governmental entities that choose not to honor ICE detainer requests and that also decline to detain individuals solely on the basis of an ICE detainer request. So NAPABA opposes supporting ICE. Is that correct?
From what you just read, Senator, I guess I haven't read that statement, but I can tell you, Senator, that I don't ascribe to any of those statements that you just read to me.
Judge, in October of 2020, you ran for judge, is that right?
Yes.
Okay. And on a talk radio interview, here's what you said. I'm going to quote.
Okay.
It's okay. We also need to recognize the effects of racism on our criminal justice system. Institutional racism impacts all of society. I think that is amplified in our criminal justice system. We see that in the disproportionate number of black men and women being incarcerated and convicted, end quote. Did I read that correctly?
Senator, I haven't listened to that particular show, but I'll take your word for it.
Yeah, okay. What do you think our criminal justice system is institutionally racist, do you?
Senator, I don't believe that our court system, by its nature, is racist.
Why did you say this then?
Well, what I meant by that was that I believe there are racial disparities in our communities.
Yeah, but that's not, we both know there's racism in every society, unfortunately.
Mm-hmm.
But that's not what you said. You said the criminal justice system is not just racist, it's institutionally racist. And then you said that, I'm going to quote your words, not mine, the disproportionate number of black men and women incarcerated and convicted are because of race. Did you say that?
Senator, what I was talking about was the racial disparities in...
And you said it solely has to do with the color of a person's skin. You really believe that, Judge?
Well, no, Senator, I don't believe that at all.
Why did you say it? You said it, you were running for judge, you said it in front of God and country on a live.
What I said, Senator, was that I recognize that racial disparities in our community can influence rates of incarceration.
That's not what you said. You're a political activist, aren't you, Judge?
No, not at all, Senator.
Yeah. Okay, I'm over. Thanks, Mr. Chairman, for your indulgence.